My name is Delene Grant, Ontario Superior Court of Justice, motion record and order. I did not respond to the deception of NAIMARK law firm and the motion or order filed in the court to be released from MANULIFE Insurance Company and Mobility Inc. My long-term disability and wrongful dismissal cases were never reviewed by NAIMARK law firm since retained on July 26, 2019. That meant that I had no obligation in attending anything or responding to anything. Am I correct? Yeah. Okay. I believe I'm correct. Please see details on the discrimination deception of NAIMARK law on the reason why I did not respond to the order. NAIMARK law was intentional when they held on to all my cases and did their own thing to cover for all the other entities. Okay? Since I retained NAIMARK law, I was being misled to delay my cases. And I'm sure you will agree with what I said, okay? Yeah. The following documents that were filed in the court of law had opened my eyes even more to the deception of NAIMARK law firm. Motion filed in the Superior Court of Justice against me in 2021. Please compare and see the deception of NAIMARK law firm. I believe you would remember these two, okay? I brought it forward in two presentations prior, okay? When I realized what really happened, I brought it forward then. Now here it is. All right. Remember, Benjamin Law has scheduled the examination for discovery long-term disability for August 16, 2019. Because I was coerced to transfer all my cases to NAIMARK law in July, right? And eventually I moved all my cases over, including long-term disability. It is obvious that the examination for discovery for August 16, 2019 would be cancelled. All right. However, seeing that it was ready for examination for discovery, right? I would believe that NAIMARK law would reschedule maybe 3-4 months later, right? Okay, waiting for the rescheduled letter, right? But instead I got a letter, and as you can see, dated September 26, 2019. All right. 2 months after retain. Okay, and the letter stated that it was Grant versus Mobility Inc. Date of loss May 24, 2018. This definitely meant that they were talking about the wrongful dismissal case. All right, and that it was scheduled for Friday, May 15, 2020. Okay, and therefore, since retained in July 2020, I will have to wait 10 months, okay? 10 months for the wrongful dismissal, okay? And I didn't really like that, but okay, what could I do, right? Still waiting for the long-term disability, waiting, okay? When I actually found it out was in 2022. What happened? Because if you notice, I'm sure we went through NAIMARK law and you see what had happened, right? That's why I brought it forward. So my long-term disability examination for discovery was actually scheduled by the court for May 15, 2020. Can you see that, right? It says examination for discovery, MANULIFE Insurance and Industrial Line, long-term disability. This is long-term disability, right? And so the Superior Court had it for May 15, 2020, as you can see. Yet, NAIMARK law firm informed me that it was Bell Mobility Inc. Date of loss May 2024, 2018 for wrongful dismissal. So while they are telling me this, that's NAIMARK law, the lawyer was supposed to be competent. Were they incompetent, or were they trying to delay my case. If they were incompetent or trying to delay my case, I do not want this lawyer. This lawyer is not good at all. That's what I would say. Either which way, they're not good. Because they're not on top of things. The court has long-term disability. Why are you telling me wrongful dismissal? You see that? All right? Okay, move on. Okay, we went through this. Proof, okay? How I was misled. Court had it on October 3rd, 2019, that it was manufacturer's life, while the letter that I received, okay, at the date of September 26, 2019. Okay, Grant versus Bell Mobility. All right, please feel free to review. Thank you. And then they didn't do anything. They just wanted to delay my case, and I just believe it was actually deceive. They were trying to deceive more than anything else. So they said, oh, because of COVID, the defense did not trust Zoom, so they asked that the discovery be cancelled until September. So May 6, 2020, got this. All right, Grant versus Mobility. May 20 and date of loss May 2024, 2018, and it says it was rescheduled for the examination for discovery. That is right, rescheduled for September 29, 2020, as you can see. All right, if they were actually working on my cases or had my interest at heart, wouldn't they, for between that the 10 months there, wouldn't they recognize that they had the wrong thing, they had the wrong information? Okay, so what the court had manufacturer's life insurance, long-term disability, okay, and the date was September 29, 2020. All right. Say no, definitely. The client for NAIMARK law was told as wrongful dismissal, right? While the court had long-term disability. The wrongful dismissal was on hold. I got fired in 2018 and wrongful dismissal was on hold. So nothing was done because of the damages I had on Bell Mobility. So they are trying their best. So this was false information, false communication to hold off. All right, please feel free to review. And as you can see, May 6th, the court, this is court information. All right, manufacturer's life. And as I said, May 6th, I got false information. All right. Yeah. And also remember, up to May 6th, I still did not hear anything about my long-term disability examination for discovery. NAIMARK law had both cases, and although the examination for discovery long-term disability was cancelled on August 16, 2019. May 6, still no mention, none whatsoever. I've not met with a lawyer and there was no mention of long-term disability. All right? Deceitful. Cancellation of the examination for discovery dated September 29, 2020 without my consent because of NAIMARK laws, deception or negligence. You see, they keep putting things off, eh? Keep putting things off because they did not intend to deal with it. Guess they're trying to frustrate more than anything else. Okay. There was a deliberate stall on a wrongful dismissal case. Yes, to protect Bell Mobility and MANULIFE insurance. But at this point in time, wrongful dismissal, Bell Mobility, there was a deliberate stall. The lawyers knew that I got a good case. So from NICOLINI not retaining me in 2018 when I was fired from my job, okay, with a work-related injury and without severance pay, 20 years of work and without severance, they knew I had a very good case and evidences on Bell Mobility and NICOLINI law, right? Unknowing at the time that he had joined with the defense. That's why I was never retained by NICOLINI law. And then it was almost a year later. almost couple months of a year, okay, that I retained SAMFIRU TUMARKIN law. SAMFIRU TUMARKIN law, right, draft statement of claim, and he got a statement of defense, so all was needed now was the examination for discovery, okay? And you all knew what happened. Please feel free to go back under the presentation. Oh, they tried to confuse everything, combine claim, NICOLINI law did some unlawful acts, okay? Then here NAIMARK law came in the picture, and you knew how NAIMARK law came in the picture. So NAIMARK law had my case, knew it was ready, wrongful dismissal, knew it was ready for examination for discovery, okay? I got a letter from NAIMARK law in September 2019 stated that my examination for discovery, wrongful dismissal, as you can see in previous slides, would be in May 2020. Right? And then whatever excuse, which, oh my, that, I knew it was a delay. That's why it was postponed again to September 29, 2020. That excuse that I got in May 2020 was not good. You understand? It was not good. But anyway, I had to wait a few more months. So here now, we're at September 29, 2020, right? The lawyer tried to find every excuse in the book to cancel again. Well, at this time, cancel, not even postpone, cancel to go to a mediation because they ran out of excuses because whatever they said just did not make sense, and I was there to defend my case, okay? So now they want to push for mediation. So now they're going to tell me that the wrongful dismissal documents have not been provided to us as yet. Really now, okay? Everything they got. It's now over a year from retained. And nothing yet where my case. This lawyer did nothing for the wrongful dismissal case. Nothing at all. SAMFIRU TUMARKIN did it all. This lawyer took my case and sat on it. Now to give me another excuse to say they don't receive the documents as it. Please feel free to review as you go along. Thank you. When NAIMARK law cancelled my examination for discovery, they were in breach of their own contract. You see, they went against my will to cancel. Okay, here it says client to make all critical decisions. I have it in a larger view on the next slide. Okay, better view of it as it says. The firm will not, however, make decisions of the client in relation to resolution. The client hereby acknowledges that it will make all critical decisions with respect to resolving their claims. NAIMARK law supposed to make non-critical decision, and this was in a contract. All right, see, they have a contract, and they didn't go by their contract. They know the law, the rules of procedure or something like that, and they're not going by it. Okay, why are they lawyers, eh?